The phrase "a legal earthquake" evokes tectonic inevitability, sudden, irreversible, and transformative. But in the American Republic, and especially in its law, the metaphor of rupture must be applied with caution. The idea that Donald Trump's business empire is finally crumbling would be a dramatic claim if it meant that his sprawling network of companies, properties, brands, and financial interests has collapsed like an unstable levee. But the reality, as revealed by documented, verifiable legal developments, is more nuanced and contingent than apocalyptic imagery suggests. What happened and what is happening centers on a civil prosecution in New York brought by the state's attorney general under a broad state anti-fraud statute, executive law. That statute empowers the attorney general to seek remedies against persistent business fraud, including disgorgement of ill-gotten gains, restitution, injunctions, and in extraordinary cases, cancellation of business certificates. In 2023 and early 2024, after a multi-year investigation, trial proceedings, and summary judgment on liability, Justice Arthur Engoron found that Donald Trump, his company, the Trump Organization, and certain executives, including his adult sons, committed persistent financial fraud by significantly overstating assets and inflating Donald Trump's net worth on annual financial statements provided to lenders and insurers. Those statements were used to secure loans and other favorable terms. The trial concluded in January 2024, and in mid-February of that year, Engoron entered a judgment finding the defendants liable for fraud. The judgment included substantial monetary penalties in excess of $450 million, with interest and accrued costs, and various restrictions on business operations within New York. It also imposed bans, a 3-year prohibition on Trump serving as an officer or director of any New York corporation, with similar lesser bans on Donald Trump Jr. and Eric Trump. These were not criminal punishments, they were civil remedies designed to deter and remediate harm caused by deceptive business practices. Civil fraud litigation, by definition, does not and cannot subject defendants to jail terms. It seeks remedies like restitution and disgorgement. Importantly, the judge's ruling was subject to appeal, a normal and expected part of the American legal system. If one were to summarize the immediate effect of the judgment at face value, it suggested a serious blow to the prestige and operational freedom of Trump's New York enterprises, particularly the flagship real estate entities that have long been symbols of the Trump brand. But even that interpretation must respect what the courts actually ordered and what appellate courts later did. In August 2025, an intermediate state appeals court upheld the underlying finding of liability that the financial statements were materially misleading, but vacated the monetary penalties against Trump and others as excessive and unsubstantiated by demonstrated harm. By doing so, the appeals panel eliminated the over $500 million judgment and effectively removed the most consequential civil liability that had been assessed. The court acknowledged that the anti-fraud statute requires proof of actual injury to counterparties, not mere inflated figures. This judicial nuance matters. Without sustained, substantiated financial penalties and enforceable operational restrictions, the narrative that Trump's empire is crumbling exaggerates both legal impact and business reality. A legal earthquake that merely shakes superficial structures but leaves core load-bearing walls intact is more a tremor than a tectonic shift. That an appeals court has remanded for reconsideration of sanctions reflects the essential fact that American justice is inherently iterative. Trump has also vigorously resisted the New York case's outcomes, both in law and in rhetoric. He and his lawyers appealed on multiple grounds, contending that the anti-fraud statute did not authorize the Attorney General's suit in the absence of identifiable direct victims with demonstrable loss. They also argued that the relief sought was excessive and unconstitutional, and that certain pretrial rulings suggested judicial bias. The appellate decision vindicated some of these procedural and substantive complaints, even while affirming the core finding of overvaluation. This legal episode is far from the only or even the central legal pressure on Trump. He has faced multiple criminal indictments in jurisdictions ranging from Georgia to federal courts for a spectrum of alleged conduct, from interference with the 2020 election process to mishandling of illicit documents. Those charges are unrelated to the civil fraud case in New York and proceed under entirely different legal standards, evidentiary rules, and burdens of proof. Conflating them with the Trump Organization's civil challenges obscures important distinctions in American law. From a principled perspective, two broader points merit emphasis. First, the American legal system, particularly in business and civil contexts, is not designed to obliterate business empires on a whim. It is designed to adjudicate disputes, remedy unlawful conduct, and restore parties to the position they would have occupied absent wrongdoing. That is why civil remedies have limits. Judges cannot give what plaintiffs do not prove. Monetary penalties and injunctions flow from proven injury, not from public displeasure or political sentiment. Appealing a judgment and seeking stays of execution are normal rights in our legal framework. Second, pundits, partisans, and commentators often reduce complex legal proceedings to dramatic metaphors because seismic language sells attention, but reality is more prosaic and less predictable. A civil finding of liability does not in and of itself ensure the liquidation of assets, the dissolution of companies, or the instant end of a business brand, nor does an appeals court's vacating of a financial penalty guarantee vindication of all defenses. It means the case continues to evolve within the law's procedural architecture. To be sure, the episode has reputational consequences. For decades, Donald Trump's self-crafted image has rested on the assertion that he is a master deal maker and business genius, an image he parlayed into celebrity, wealth, and political capital. A judge's detailed findings that assets were materially overvalued, that net worth figures were routinely inflated on financial statements, and that lenders and insurers were misled cut against that narrative. Yet the essential question remains, do these developments signify the crumbling of Trump's business empire? Or do they signify that the courts have applied the law to specific conduct in specific contexts, with consequences that are serious but neither uniformly destructive nor terminal? From a conservative viewpoint grounded in respect for both individual enterprise and the rule of law, one must resist hyperbole. Enterprises rise and fall based on myriad factors: market conditions, consumer demand, debt structures, managerial competence, and yes, legal risks. A corporation or real estate portfolio may shrink, restructure, or be forced to disgorge profits if wrongdoing is found. But an empire does not necessarily collapse because of one civil judgment, especially where that judgment has been modified by appellate review. If Trump's business network were truly on the brink of liquidation, we would expect sustained enforcement actions, unassailable judgments, and resulting receiverships or forced sales of core properties, and we have not seen that. The New York case, while serious, has not resulted in wholesale corporate dissolution, receivership appointments, or forced divestiture of marquee assets. Indeed, the appeals court's decision underscores that even robust assertions of fraud must be measured against clear standards of proof and legislative intent. Nor should we forget that much of Trump's brand value, licensing operations, and broader business footprint extends beyond the narrow jurisdiction of New York law. Commercial rights, licensing deals, golf courses, trademarks, and international real estate investments operate under different legal regimes, often outside the reach of a single state's courts. If his name still commands value, or if licensing revenue continues, then the notion of a bankrupt empire is premature at best. In political terms, the optics of legal struggles matter and influence public opinion. To some, any legal setback for a high-profile figure is evidence of decline. To others, it is proof of persecution. Conservatives committed to the rule of law should not cheer a crumbling for its own sake, nor should we minimize the seriousness of proven misconduct. The proper conservative stance is to uphold accountability while demanding rigor and fairness. What is clear and must be stated plainly, after judicial scrutiny, a New York judge found Trump and his company liable for civil fraud in how they presented financial information, and substantial penalties were assessed. That was a serious legal event, but on appeal those penalties were vacated as excessive, though liability findings were sustained. The case has not produced irreversible dismantlement of the Trump Organization, nor has it rendered Donald Trump's broader business interests null. The story, therefore, is not one of instant ruin, but of institutional friction between a business culture accustomed to aggressive self-presentation and a legal culture that insists, sometimes belatedly, on documentary precision. The Trump Organization was never a publicly traded corporation subject to the relentless discipline of quarterly disclosures and shareholder scrutiny. It was a privately held, family-run enterprise whose valuation practices existed in a gray zone between puffery and precision. The New York court concluded that this gray zone was crossed repeatedly and knowingly. That conclusion carries moral and legal weight, even if the financial consequences are now less draconian than first announced. It is also important to recall that American capitalism has always tolerated and at times celebrated a degree of exaggeration. Business history is replete with figures who describe their assets in the rosiest terms, believing that optimism is not merely permissible but essential to entrepreneurship. The law, however, draws a line where exaggeration becomes material misrepresentation, where numbers are not simply hopeful but demonstrably false, and where those numbers are used in formal financial statements presented as accurate. The New York court's finding rests on that distinction. Whether one believes the line was drawn too aggressively is a legitimate subject of debate, and one that appellate courts partially engaged. From the standpoint of conservatism properly understood, not as reflexive defense of any businessman, but as respect for ordered liberty, the discomfort here is twofold. First, there is unease about the breadth of the statute employed. Executive Law 6312 grants extraordinary power to the state attorney general, requiring neither proof of intent nor proof of direct victim harm at the liability stage. That concentration of discretion in a political office should trouble anyone wary of expansive state power. Second, there is the risk of retroactive moralizing, judging long-standing business practices by newly sharpened standards, applied selectively to a politically polarizing figure. Yet acknowledging those concerns does not require denial of facts. The court record contains detailed comparisons between internal valuations and public representations, between conservative appraisals and exuberant statements of worth. These were not marginal discrepancies. They were, in some instances, differences of hundreds of millions of dollars. The defense argued that lenders conducted their own due diligence and were not misled. The court responded that the existence of independent verification does not excuse the provision of false data. Reasonable minds can differ about whether that response stretches the law beyond its intended scope, but it is not fanciful and it is not invented. The deeper question then is whether this episode marks a turning point for Trump's business future or merely another chapter in a career defined by litigation, leverage, and survival. Trump has been involved in thousands of lawsuits over decades, many of them routine disputes arising from the scale of his operations. He has lost some, won others, and settled many. His business model has often relied less on pristine balance sheets than on brand recognition, media attention, and the monetization of his name. That model is oddly resilient to traditional notions of reputational harm. Indeed, one of the paradoxes of contemporary politics and media is that notoriety can function as capital. For Trump, legal conflict has often reinforced his public persona rather than diminished it. Supporters interpret legal setbacks as evidence of hostility from entrenched institutions. Critics see them as overdue accountability. In either case, attention is sustained, and attention in Trump's world has monetary value. Licensing deals, media ventures, and fundraising efforts have at times benefited from controversy rather than suffered from it. This reality complicates claims of crumbling. Empires crumble when revenue streams dry up, when debt obligations become unserviceable, when assets are forcibly liquidated. None of those outcomes has occurred on a systemic scale. Trump remains wealthy by any conventional definition, though precise estimates of his net worth vary widely and are inherently speculative. His properties continue to operate. His brand, while polarizing, remains recognizable globally. Even the temporary bans imposed by the New York court did not amount to a permanent exile from commerce, and appellate intervention softened their impact. There is also a constitutional dimension worth noting. The United States is a nation deeply ambivalent about wealth and power. We admire success and resent it. We celebrate entrepreneurship and suspect it. High-profile prosecutions of wealthy individuals often carry symbolic weight beyond their legal particulars. They become morality plays, proxies for broader arguments about inequality, privilege, and accountability. In such plays, nuance is often sacrificed to narrative clarity. The villain must fall, the edifice must collapse. But law does not operate by dramaturgy. The conservative intellectual tradition at its best resists such simplifications. It insists that law be applied without regard to popularity, that punishment be proportionate, and that institutions restrain rather than indulge passions. That tradition neither excuses fraud nor endorses punitive excess. It asks instead whether rules are clear, evenly enforced, and consistent with constitutional principles. On that score, the New York case raises legitimate questions even as it answers others. One question is whether similar valuation practices are widespread among private real estate developers, and if so, why enforcement has been so selective. Another is whether civil penalties untethered from demonstrable harm risk transforming regulatory law into a tool of political signaling. The appellate court's decision to vacate the monetary penalties suggests judicial awareness of these dangers. It reflects a recognition that even when wrongdoing is established, remedies must be grounded in evidence, not outrage. It is also worth observing that Trump's political ambitions complicate every analysis of his business affairs. Were he a retired developer living quietly in Florida, this case would have attracted far less attention. That does not invalidate the prosecution, but it does contextualize the fervor surrounding it. The law must be blind to political status. Yet politics is rarely blind to law. This tension is unavoidable in a republic where ambitious individuals straddle multiple spheres of influence. Ultimately, the notion of a legal earthquake implies finality, a before and an after, a permanent shift in the landscape. What we have instead is a prolonged tremor, significant, unsettling, but not conclusively transformative. The courts have spoken and will likely speak again. Trump's business practices have been scrutinized and found wanting in specific respects. Consequences have followed, though they have been moderated by appellate review. The empire, such as it is, remains standing, albeit whether it endures or declines will depend less on this single case than on broader forces. Market conditions in commercial real estate, the evolution of Trump's brand in a divided culture, the outcome of unrelated criminal proceedings, and the strategic decisions of Trump and his heirs. Law can constrain, punish, and correct, but it rarely determines destiny alone. To describe this moment as the definitive crumbling of Trump's business empire is therefore to mistake process for conclusion. It is to impose narrative closure where the law characteristically offers none. The American system prefers gradualism to guillotines, appeals to final judgments, and correction to catastrophe. That may frustrate those who crave dramatic endings, but it is also what protects Parrott from the excesses of power, whether wielded by moguls or magistrates. In that sense, the most important lesson of this episode is not about Donald Trump at all. It is about the resilience of institutions, the limits of state authority, and the necessity of skepticism toward claims of irreversible collapse. Empires, like reputations, are rarely destroyed in a single stroke. They erode, adapt, or persist over time. The law's role is not to hasten their demise for spectacle, but to enforce rules with sobriety and restraint. The temptation to declare an ending is especially strong in an age addicted to immediacy. We live amid headlines that announce downfall before the dust has settled, verdicts before appeals are exhausted, and moral reckonings before facts are fully digested. Donald Trump, by virtue of his personality and prominence, has become a magnet for this tendency. Each adverse ruling is framed as the long-awaited reckoning, each favorable ruling as an aberration or outrage. Serious analysis requires a cooler temperament. If one steps back, the Trump organization's trajectory looks less like a collapsing tower and more like a business that has always operated at the edge of conventional norms, now encountering intensified scrutiny. That scrutiny is not accidental. Trump placed himself at the center of American politics, and in doing so invited examination not only of his public conduct, but of the private representations that undergirded his claims of success. The law is an instrument ill-suited to symbolic purification, but well-suited to methodical inquiry. What it has produced here is an inventory of practices that, while perhaps long tolerated, were ultimately judged incompatible with statutory requirements. There is also a cultural element at work. Trump's rise coincided with a broader erosion of trust in institutions, financial, governmental, and journalistic. His supporters often interpret legal actions against him as proof that those institutions are weaponized. His critics see the same actions as overdue accountability for a man who has evaded consequences too long. Both interpretations oversimplify. Institutions are neither monolithically corrupt nor flawlessly virtuous. They are human constructions capable of error, bias, and correction. The appellate court's partial reversal illustrates that self-correcting function at work. It is fashionable in some quarters to argue that Trump's business success was always illusory. a house of mirrors sustained by debt and bravado. That argument ignores stubborn facts. Illusory empires do not persist for decades, do not own prime real estate, and do not generate licensing revenue across continents. At the same time, it is equally naive to accept Trump's own maximalist claims at face value. The truth, as usual, lies between caricatures, a businessman of genuine skill in branding and negotiation, coupled with a chronic indifference to the disciplines of accounting exactitude. The law's intervention exposes that indifference. It does not, however, retroactively nullify every deal, every property, or every instance of wealth creation. To insist otherwise is to confuse moral judgment with economic reality. Markets are unforgiving in their own way, but they do not respond to judicial opinions with instant obedience. They respond to cash flow, risk, and perception. If lenders continue to see value, if partners continue to sign contracts, the enterprise adapts. If they do not, it contracts. That process unfolds over years, not news cycles. One should also consider the generational dimension. Trump's children, now deeply involved in the organization, face a different environment than their father did. They inherit not only assets, but scrutiny, not only a brand, but a burden. The court-imposed restrictions, even when softened, signal that the era of casual informality in valuation and disclosure is over. Whether the next generation internalizes that lesson will shape the organization's future more than any single judgment. From a constitutional perspective, there is a cautionary note worth sounding. The expansion of civil enforcement powers, particularly when wielded by elected officials, must be watched carefully. Laws intended to protect consumers and markets can, if stretched, become instruments of discretionary punishment. The line between legitimate enforcement and politicized prosecution is not always bright, and its erosion would endanger not only controversial figures but ordinary enterprises. Conservatives, of all people, should be alert to that danger, not because Trump is uniquely deserving of protection, but because precedents endure after personalities fade. At the same time, a conservatism that degenerates into reflexive defense of any figure labeled anti-establishment abandons its intellectual heritage. Edmund Burke did not counsel indulgence of misconduct. He counseled reverence for order. Order requires rules, and rules require enforcement. The challenge is to ensure that enforcement is principled rather than performative. The New York case straddles that line, enforcing genuine standards while flirting, at times, with excess. History suggests that business empires rarely end with a bang. They fade, fragment, or are transformed by forces larger than any individual. The Vanderbilt fortune dissipated through generations. The Rockefeller empire evolved into something unrecognizable from its origins. Even those collapses were not precipitated by a single lawsuit, but by shifts in law, technology, and culture. Trump's enterprises exist in a similarly fluid environment. Real estate markets change, media ecosystems evolve, and political fortunes rise and fall. Legal judgments are part of that environment, not its totality. So what remains after the rhetoric is stripped away? A factual residue. A court found persistent misrepresentation. An appeals court curtailed the penalties. The business continues. The political drama persists. That is not a morality tale with a tidy conclusion. It is a snapshot of a republic grappling imperfectly with the intersection of wealth, power. Those who insist that Trump's business empire is finally crumbling may yet be proven right, but not because of this case alone. If decline comes, it will be cumulative, the result of sustained pressure from markets, regulators, and public opinion. Those who insist that he has been fully vindicated are equally premature. Liability was affirmed. Conduct was condemned. Neither triumph nor ruin has been conclusively established. In the end, sobriety is the most conservative virtue here. The law has spoken, but not with finality. The empire stands, but not unscathed. The republic endures, as it always has, through dispute and correction. That endurance, not the fate of any one businessman, is the proper measure of our concern.